Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk, and thanks for watching. We have a busy docket. First, Lori Vallow. The police issue a statement on JJ's 8th birthday. We also have a preliminary hearing coming up. Let's talk about what the prosecution has to show. Second, Suzanne Morphew case update. The home has been released back to the family. Third, I Can't Breathe 2.0. Fourth, Ahmaud Arbery case. Things may have just got a little more complicated for the McMichaels. Fifth, an example of why you shouldn't drink and drive. And yes, our dumb criminal contestant of the week, as well as some scheduling announcements. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch. Thanks for tuning in. First, if you have not subscribed, we would ask you to do so. Please leave us a comment as to what we discuss here today. We appreciate it. First, before we get to the docket, a scheduling announcement. We will be going live tonight at 6 p.m. Mountain Time on our Facebook page, Crime Talk. We will be there for one more week exclusively on Facebook because on June 3rd, we are out of YouTube detention. So first on the docket, Lori Vallow. For those of you who do not know, she is sitting in an Idaho jail, currently awaiting charges of abandonment of her children, specifically her daughter, Tylee Ryan, and her son, JJ, who just turned 8 on Monday. The police in this particular case, issued a statement saying that they continue to hope and pray for the safe return of both of these beautiful children each and every day. That was from the Rexburg Police Department Assistant Chief Gary Hagan. And there's a lot of talk and speculation. Vallow's mother and sister have made comments that they think that the children are safe and that she must have a good reason for that, but nobody seems to know what the reason may be. This case also seems to attract a lot of attention, given the fact that there is simply just a lot of weird circumstances regarding Lori Vallow and the people around her, specifically her new husband, Chad Daybell, his wife, Tammy, dies just 2 weeks before they run off and get married in Hawaii. Lori Vallow's daughter, specifically Tylee, was last seen hiking in Yellowstone National Park on September 8th. All traces of JJ vanished about September 23rd of last year, but the grandmother, Janice Cox, said that she had spoken with the missing 7-year-old on or about October 1st, which of course led to Chad Daybell and Lori Vallow running off to Hawaii, ignoring orders from the courts in Idaho, which ultimately led to their arrest. To make this case even more intriguing, there was an email released from the Phoenix police last month revealed that investigators were close to charging Lori in connection with Charles Vallow's death. Now, the preliminary hearing will be coming up in the Lori Vallow matter in June. Now, we'll see how this goes, but at a preliminary hearing, you have to remember the government does not need to present all of their evidence in this particular case. They simply have to present enough evidence to establish probable cause. Would a reasonable person believe that a crime was committed and that Lori Vallow may have had something to do with it? It's a very low standard, much different from proof beyond a reasonable doubt, which is at trial. However, whether it be at trial or the preliminary hearing, the district attorney has to satisfy certain elements of the charge. And for the desertion of a child charge in the state of Idaho, the government would have to prove the following. The first element that they would have to show is that on or about a certain date in the state of Idaho, and they would list the children's name in the jury instruction, that would be specifically Tylee and JJ, and that they were under the age of 18 and hence a child. Fourth, they would have to show that they were dependent upon the defendant, Lori Vallow, for care, education, or support, and the defendant deserted such children. and they would have to also prove that it was with the intent to abandon the children. Those are the elements that they would have to present to keep the case going forward, as well as present evidence beyond that would satisfy a jury based upon the proof standard of proof beyond a reasonable doubt that the children were in fact abandoned. Now we know that the prosecutor has lots of evidence, but they don't know where the children exactly may be. But it would make sense that a mother would have no problem showing where the children might be so that they can say they were never abandoned. They are simply in the care of a particular individual. Now, if that were really the case, I would think through their defense attorney, Ms. Vallow would in fact tell the defense attorney to go get the children and produce them to show that the children are safe and there was no abandonment so that they could basically get on with their life. Now, reason and common sense also seems to dictate that perhaps their children are deceased and therefore they cannot be produced. The defense in this particular case doesn't get to run afoul of all kinds of conspiracy theories or speculation. They simply have to disprove even just one element, and if a juror was not satisfied, proof beyond a reasonable doubt, then that would be it. So, for example, those particular elements. Obviously, the children were 18. The district attorney would introduce birth certificates. Pretty straightforward. They would have to show that Lori Vallow was primarily responsible for the care, education, support of these children. We know that they were enrolled in school. She disenrolled them from school. We knew that JJ had a therapy dog that was returned. All those types of things and evidence would be presented to show that she was responsible for care, education, support, and basically it all stopped. Deserted such children. I looked through the criminal code, couldn't find an actual definition for desertion of children, but it clearly shows that one intends to abandon, not take care of, leave, complete disregard in the future of these particular children. And then you'd have to show that it was the intent to abandon the children. Well, how simple is that? You show Lori Vallow ran off to Hawaii and did not return voluntarily, and she didn't take her children with her. And it appears as though she made no plans to have anyone take care of these children in the future, at least not to our knowledge. Prosecutor doesn't have to disprove everything that the defense could possibly raise, but this is an interesting kind of statute because although the defendant never has the burden of proving themselves innocent, it clearly puts somewhat of an onus on the defense to actually show what happened to these children. This will be an interesting case to watch. I'm telling you, this is just, I think it's an interesting case because you have a mother who has two children and they just disappear. Who thinks that no one is not going to notice? And then she just nonchalantly goes about her life and gets married and goes on a honeymoon and never even bothers to try and get these children, call them, even from jail. Wouldn't you try to call your children, let them know you're okay? You would think so. No one will defend anyone's right to presumption of innocence as a criminal defense attorney for some 25 years. However, like we discussed last week, as a defense attorney, sometimes you have to tell the defendant how bad the case is. And doesn't seem to be a whole lot of good information out there for Lori Vallow. And once her attorney pretty much got shut down at the last bond reduction hearing, he's been pretty quiet. I would say that he has been humbled. Next on the docket, an update on the Suzanne Morphew case. For those of you who are not familiar with the case, Suzanne Morphew disappeared on Mother's Day of this year. It's alleged that her husband, Barry, was in Denver for some sort of trip and that she went for a bike ride on Mother's Day morning. There was initial reports that somebody actually saw her riding her bike, and now there are reports that maybe no one actually did in fact see her riding her bike, but her bike was ultimately found in the general area of her neighborhood. The police have searched reservoirs. They've searched a very large area, And they searched the residence of an individual that had Barry Morphew do some landscaping work at that particular home. Now, there's nothing to say that the residents had any involvement in anything related to the disappearance of Suzanne Morphew in any way. In fact, the police went out of their way to stress that they were, in fact, very cooperative. There were pictures taken Friday afternoon where it appears that the police cut out a patch of concrete at this particular residence, and it wasn't clear why they were doing that. The police are being very quiet about their investigation. In fact, the family is reportedly not in the loop as well. We do know that Barry Morphew's phone and his vehicle were seized by the police early on in this investigation, and the house was only released as of today, so the family can now return. But those were all seized pursuant to court-ordered search warrants so that they can go through the house and look for anything of evidentiary value. I've received several tips, so to speak, regarding where this case may have been going, but I couldn't corroborate that information, so we're not going to report it until we can actually do that. As it relates to the Suzanne Morphew case, her husband, Barry O. Morphew, has been very quiet and has not spoken directly to the media. He put up a very brief video on social media asking that his wife be returned, come home. You can use your own judgment as to whether you think some of his language was typical, atypical. I'm not a big fan of looking at body language, particularly on people that I don't already know. We've seen these types of situations where a lot of people jump the gun and say, oh, the boyfriend, the husband had something to do with it, and it turned out to be completely wrong. Exhibit A, the Heidi Broussard case, when a lot of people were saying that the boyfriend, Shane, had something to do with it, I said, hold on, he's given the presumption of innocence, and it turned out he had nothing to do with it whatsoever, and it was her best friend who's now ultimately been charged for her death. But I thought that this would be a very good opportunity to show you what we can do when we're looking up information related to a potential witness or a potential person of interest. And as we stated last week, we had a new sponsor, People Finders, and if you go to CrimeTalkSearch.com, you can sign up. It's a low monthly subscription fee. You can quit at any time. Listen, they want to help Crime Talk grow and expand, be able to provide more information to you, and we are going to try to help them in return. It's that simple. So we ran a report on Barry Morphew. There's not much there on Mr. Morphew. I mean, obviously they moved from Indiana up to Salida, Colorado. There's no bankruptcies. There's no liens. The only judgment we could possibly find was from Indiana in small claims court for a whopping $320. Mr. Morphew has had several businesses. It's been reported that he is an EMT or a paramedic, but that's not particularly surprising. A lot of EMTs, paramedic, firefighters have kind of side gigs because of their work schedule. It allows them to have a lot of time off. And we also know that Mr. Morphew sits on the board of the Suzanne R. Morphew Hope Foundation, which in fact lists as a organization to address the needs of children in various global locations by showing the love of Jesus Christ in tangible ways to address recognized needs. Now, this Suzanne R. Morphew Hope Foundation, Inc. was also listed as an organization that Suzanne Morphew was involved in Indiana and then later transferred here to the state of Colorado. Mr. Morphew has no prior criminal arrest record. The only thing that turned up was a driving 15 to 20 miles over the speed limits in Indiana in 2012. So no criminal history what to speak of. What's also available here, not only can you do a background search, but if you have a phone number and that's all you have, you can plug that in to see if you can find the phone number by doing a by doing a reverse phone look. If you have an address, you can simply look up the address and see who owns it, property records, which can lead to many, many things. Also, if you have an email address, and I used this literally a couple years ago. We had a case, it was anonymous, it was a real weird type of situation, but only thing that ever came up was an email address. And we searched, we had investigators do it. We finally looked as a Hail Mary attempt, we looked on People Finders. It came up to a name. Through that name, we found an association with a particular individual, and it helped resolve the matter. You could go do this on your own, look through thousands of databases everywhere, but when you have it all right here for literally $4.95 a month, you want to search the babysitter, the friends, the new people that moved in across the way, maybe the guy or woman that you're going to go on a date with you don't know anything about, or maybe somebody you just have known for a while and you're not sure if you get that warm, fuzzy feeling. This can do it all in a matter of minutes. They're helping us out. Let's see if we can help them out as well. No one's forcing you to do anything. You can cancel at any time you would like. Next on the docket, I Can't Breathe 2.0. Yep, that's right. I Can't Breathe 1.0 was the Eric Garner case out of New York several years ago where the man died stating he could not breathe. Basically, no criminal charges were ever brought against the police officers in that particular case. In the I Can't Breathe 2.0, this took place in Minneapolis, Minnesota. And the man in the video, although he's not been identified, died a short time after the arrest. Now, what we do know is the police were called to this particular location to investigate a forgery of some type. Apparently, the man, possibly homeless, possibly under the influence of drugs or alcohol or a combination of both, and possibly even may have resisted the officers for a moment. The officers then put the man in cuffs, put him down on the ground, and literally then put their knee on the man's neck. You can hear him on the video saying, "I can't breathe," repeatedly several times. Throughout the 10-minute video, which was put up on a Facebook page, you can hear concerned citizens saying, "I don't think he can breathe." And you can tell as the video goes on that the man loses consciousness. Many of the bystanders try to alert the police of this particular situation, and the officer who has his knee on this man's neck does nothing. In fact, the other officer seems more concerned about keeping other people away and possibly not videotaping the entire incident. Well, as the matter progresses, the unidentified man dies. Yesterday, the police were put on administrative leave. As of today, the 4 police officers that responded to this scene have been fired. They may also want to get legal representation. A lot of people will come up with a lot of excuses why it's absolutely appropriate for a man who's on his stomach, handcuffed, thought it was appropriate for the officers to sit on his neck for some 7 minutes, where it also appears that he becomes limp and unconscious. At about the 7-minute mark, the EMTs arrive through the paramedics, and he's placed into an ambulance and ultimately taken to the hospital where he passes away. And that very may well be the case, that you could put your knee on someone's neck for a little while till the man is subdued. I get it. I've seen videos where people are just simply out of control and the police have to do what they have to do. I get that. But this is a case where it appears that was not appropriate. And like I said, these police officers have some trouble coming their way. The Minneapolis Police Department may also want to get their checkbook ready if this man has any family, because there will be a wrongful death suit, I'm sure. Next on the docket, the Ahmaud Arbery case. Well, things may have just got a little more complicated for the McMichaels in this particular case. For those of you who are not familiar with the case of Ahmaud Arbery, he was killed as the McMichaels, and when a third man, William Roddy Bryan, followed Mr. Arbery around the neighborhood, the younger McMichael got out of the vehicle with a loaded shotgun, and ultimately, after perhaps a struggle of some type with the shotgun, Mr. Arbery is shot. Not once, not twice, but 3 times. No one was charged in this case until a video became available actually through the McMichaels and Mr. Bryant. Mr. Bryant actually filmed the particular video, and they thought that this would, for lack of a better term, exonerate them, but it did not. It was the complete opposite because they've been charged. The United States Attorney is launching an investigation into the shooting death, whether it was in fact a hate crime. The Department of Justice is considering investigating this case to see if it warrants hate crime violations under federal law. Georgia is one of 4 states that does not have hate crime laws. Therefore, it would have to be brought via a federal case if it was decided there was sufficient evidence to do so. Additionally, the Department of Justice is deciding or weighing their options as to whether they should look into the handling of the case by the previous district attorneys who thought that there was not sufficient evidence for this case to go forward. Now, this particular case regarding Mr. Arbery has brought a lot of comments, and I get a lot of people telling me what Georgia law is. And I keep directing them back to my previous videos where we discussed Georgia's stand your ground law, which is clear that you do not have to retreat and you can stand your ground to use deadly force if someone is threatening you with a life-threatening deadly force. We've also explained the citizen's arrest statute, which clearly states, as well as the interpretation by the Georgia Supreme Court, is that you can only make a citizen's arrest if you actually see a crime taking place. We discussed the statute as well as the case law interpreting the citizen's arrest statute, which clearly states that you have to actually have witnessed the crime. From what we know, the McMichaels did not witness any crime taking place. And specifically in this particular case, Mr. Arbery, if he in fact went into the residence, if that's him, which frankly it looks and appears to be that, but there's no evidence that he actually committed a crime. So at most, this would be probably a misdemeanor trespass. It's not a burglary because you'd have to show there was intent to commit a crime therein. Nothing was stolen, so it'd be pretty tough to prove that you were going to actually steal something and then you in fact did not. We also talked about the initial aggressor statute, which a lot of people don't seem to like. And in fact, they said, well, what statute would you make? Or a lot of people said, what offense would you possibly bring up that would require a citizen's arrest where you were not the initial aggressor? Well, normally that's the chasing of the shoplifter or the person who steals the purse of the little old lady and somebody gives chase and actually does that. But those people actually see a crime taking place. But when you think somebody has maybe committed a crime, not certain of that, specifically a misdemeanor, which you can still arrest for a misdemeanor, i.e. like shoplifting, but the fact that you get out of the car with a loaded shotgun, you are the initial aggressor. And when you are the initial aggressor, self-defense does not always come in. Now, do I think that the McMichael, or do I believe that Mr. McMichael will probably get a self-defense instruction? Probably, if he testifies to the fact that he got out of the car and that the guy that he pointed a loaded shotgun at grabbed it or tried to move it, which warranted him shooting not once, not twice, but 3 times. That is going to be a hard sell. Think about it, ladies and gentlemen. After deliberation, that simply means that you have time to pause and reflect of what you could do. And I think a very good example of after deliberation is if you are driving a car down the street and as you are approaching the intersection, you notice that the light just changed yellow. And in a matter of a second or so, you've been able to look behind you, look to your left, look to your right, look into the intersection, and decide whether you should brake or you had enough safety that you could drive through it. But either way, you did that after deliberation. That's how quickly after deliberation could be. Usually self-defense is maybe 1 shot, 2, 3. After 3 shots, you're clearly thinking about pulling the trigger. So I love the spirited debate. Maybe I will be found to be incorrect when the ultimate decision comes down in this particular matter. But at this point, I am going to rely upon the law and not just defending the McMichaels, because that is the way I think that it would be. I told a lot of people they need to continue to maybe have a little self-reflection, because a lot of the people that have written comments, as well as the email that we discussed last week in my hate mail section, said that I was on some sort of anti-white agenda. No, not really. We're just looking at the law. And think about it, ladies and gentlemen. If the circumstances were flipped, all right, and a group of black men shot a white man who's supposedly out for a jog, even if he went into a house, maybe look for a hose, who knows? Maybe he was thinking about stealing a place. Doesn't matter. You can't go around shooting people. If that individual was white, these same people would be the exact outraged. Well, you should be outraged regardless of anyone's skin color in this particular situation. It shouldn't be a factor in any way whatsoever. And if race is the only basis of why you think that you are siding for one side or the other, that's intellectually dishonest, and you need a little self-reflection. Next on the docket, another example why you should not drink and drive. Well, a California man was arrested over Memorial Day weekend after spending nearly 2 hours in a car that he crashed into a pond of liquid manure. That's right. In the day of Uber and Lyft, there is no reason why anyone should drive drunk. Now, don't get me wrong. If you do drive drunk, particularly in the state of Colorado, give me a call. My firm can represent you. We have some of the best DUI attorneys in the entire state. They have worked amazing things. But I will tell generally everyone, just order an Uber, a Lyft, call a friend, walk. It's a lot less expensive than getting a DUI. So this unidentified driver told the police he crashed his vehicle into an unknown water source and was quickly filling up with liquid. When the police arrived, after about 50 minutes of searching, they spotted this partially submerged vehicle in a liquid manure pond. The driver had been in there for nearly an hour. He only contacted local authorities for help after his own attempts to exit the vehicle failed. Upon exiting of the unidentified driver, he had objective signs and symptoms of alcohol intoxication. You know, the odor of an unknown alcoholic beverage, bloodshot, watery eyes, and slurred speech, and unstable on his feet. Now, a defense attorney could probably have a pretty good time with that, assuming there wasn't a test, because all of those things could have been caused by the liquid manure that he had been sitting in for an hour. If you drive into a water source, call the police immediately, because that could have been a really, really bad situation. Next on the docket, our dumb criminal contestant of the day. And for those who were wondering and voted, yes, the Melonheads resoundingly won the dumb criminal contestant of the week. And if the Melonheads would like to come forward, contact me at scott@scottreisch.com with their address. We will send them a Crime Talk mug as their prize for being the dumb criminal contestant of the week. Our dumb criminal contestant of the day is Debra Hamill from Oklahoma. Debra Hamill was pulled over for a busted out taillight and basically refused to sign the ticket by the police officer. In fact, you can see the police officer was actually quite nice to the 65-year-old Hamill, who made it quite clear she didn't want to sign the ticket. At one point, she actually rolled up her window and drove off. The police officer then gave chase, where she was arrested and charged with felony assault and battery on a police officer.
Put your hands behind your back. Put your hands behind your back.
You can be the judge as to whether perhaps Miss Hamill should have simply signed the ticket and gone to court or paid the fine. But no, she thought that she could simply get away with it, and she did not have to. I hope when I'm 65, I have this much fight left in me as Miss Hamill, but it clearly did not go well for her. Now, her friends, the friends of Miss Hamill, have actually started a group headed by a lady by the name of Linda Lenhart, and this knitting group has also called themselves the Old Ladies Against Tasing, all to support their friend, Miss Hamill. And nearly every case of our dumb criminal contestant of the day always provides us a teachable moment. If you believe that the arrest or the citation is not valid, take your citation or take your arrest and go peacefully. You are not going to persuade the officer to change his mind. It's simply not going to happen. To challenge the legality of an arrest or whether a crime was actually committed has to be done in court. The police officer has no authority to do that. Yes, I guess in theory he could not arrest you. He or she could tear up the citation, but 99.9% chance they're not going to. And by getting mouthy, becoming belligerent, or even resisting will only result in additional charges. And certainly don't drive away until you have your ticket, unlike Miss Hamill. She may have a very valid point, but nobody's going to care about that valid point because she eluded and then she assaulted a peace officer, which resulted in her being tased, not once, but twice. So, Miss Hamill, you are our dumb criminal contestant of the day. We'll see if you can hold out your lead for the week and become the dumb criminal contestant of the week on Friday. Now, as we stated previously, we are going to go live on Facebook this evening on our Crime Talk page. That will begin at 6 p.m. Mountain Time this evening. And next week, we'll be able to go live on all of our social media channels. We hope that you'll join us. We will be talking about things that have developed from the time this video went up, as well as taking all of your questions or as many as we can answer in our time frame. Thanks for watching. Have a great day.